All right, well, let's switch it up. Okay, so I've been working on this, and I'm just starting the constitutional law questions of it, and I've had a couple of other questions, and I think it was like an overall bar model because there was a lot of questions like this in the original 50 that I took. So, a creditor initiated a garnishment action against a woman seeking to recover a past due debt from a personal loan she had taken. At the commencement of the action, the creditor had not yet secured a judgment. The creditor served the notice of garnishment on the garnishee, the debtor's employer, who complied by withholding all the woman's earnings in an escrow account pending the creditor's lawsuit and the entry of a final judgment against the debtor. The state where the debtor resided and worked had a provision allowing for pre-judgment garnishment providing the funds were held and not distributed until the judgment was entered. The money would be returned to the debtor if the judgment was not entered within the next 120 days. The debtor sequentially filed a lawsuit against her employer demanding the release of her earnings. Will the court order the garnishment of the release of the fundings? No. Let's take a look at things here. When we have to deal with some level of how this is passing through some Bohr models and other things, this would be why this key is really important to SU symmetries and this first order, because our first order of the question is this instant. This is constitutional. Let's start, because we already have the information and it's in some level of SU2, SU3, that we have to go about picking this apart. Now, again, I have an answer picked out. I haven't submitted it yet, and I haven't looked it up as far as the library either, which we're going to do in this process right here, just for funsies, keep it all together, SU3, SU4. So, why would the bar give you a trick question like this? Well, because sociopaths are sociopaths, firstly. But this would be in the idea of, if I'm correct, that the creditor really shouldn't have gone to the debtor's employer to garnish these wages, even though they have rights to the state pre-judgment in this garnishment. You can't just go to somebody's employer and just take somebody's money without due process, right? This is a violation of probably the 7th Civil Act. If I'm getting it right, again, I'm just starting to play with this stuff. So we got to go through the A function here. The creditor initiates a garnishment action against a woman seeking to recover past due debts of a personal loan. So again, she took out a loan against the creditor, probably personal bank or whoever, credit card company, could be anybody at that point in time. And they want their money back for a past due debt inside of this. She missed a payment, she stopped paying it, whatever. At the commencement of the action, the creditor had not yet secured a judgment. Well, that would generally be bad. I mean, you got to kind of poke at the wall, have a lawyer, but you can't initiate this conversation just yet anyways, because it has to do with like self-help and violating other constitutional privacy acts and things like that. But they would know because there's a personal contract inside of here. And you really got to take these periods and commas out because they mean things as far as the Lagrangian starting to build the wave function of sensible notations. And one of the things about the bar is you're not going to find that. This is kind of designed as an MCAT's cognitive skill test where I'm sure they're even aware of the internet's ability to do something like this and then check it up with Gemini, click and copy the answer. I like to go ahead and pick out, if I didn't know escrow or something, well, then you go in and you check that out. If you didn't know the specifics here, you should take the time to do this even though you blow through this process. You should take the time to take, the whole entire question and see how 79 rips it down. That answer is worthy of reading because, especially for me in my position, I'm not learning the same YouTube dev process twice, right? I already know how to do that, so I can kind of get beyond focusing to do that, but that's what this system is for. It's specifically designed to do something like that. So again, the creditor is going to garnish in the bar state. You got to be really careful with this stuff. So again, I just wanted to get to that holistic model of doing it. So let's find out. Let's actually go ahead and click and copy some of this. Let me pull this back out of here and just show you what I've been doing to AI data mine the penetration tests from a free standard out here about how we're doing it up. And we're just going to take that in there, post it. Yeah, sure, that's what I meant. And see what it tells us. Given the state's law allowing the prejudgment garnishment of wages, it is unlikely that the court will immediately order the garnishment to be released the funds to the debtor. Order the garnishee to release the fund. Here's a breakdown of the key considerations: prejudgment garnishment, safeguard. Well, that would be a fun one if you didn't know any of this or chasing some rabbit you're personally relative to. Purpose of prejudgment garnishment. Well, again, if we talked about it, that a debtor just running away, or that in a way it's like a merchant's law. They are a merchant for this product, even though it's not necessarily a grocery store. Process, consider. All right. In conclusion, while the debtor might argue for the immediate release of funds, because I would too. Until you really pick it apart and read it and say, well, no, because the state procedures of protecting the woman's money until judgment is entered is a fair one that comports with procedural due process. Well, they did. They had the state. It's in an escrow account. It's not being spun. Even if she starves on the street for what it is, that it's that kind of point. They have a right to make sure that they don't get screwed over either, because then there's just a power vacuum of a black hole left down in there. And that's kind of what I'm doing in the bar lately. I want to make sure, because on the other end, if I was right, I want to make sure that they do those things and do proper 14th Amendment procedures and things like that. Because essentially what they do, without other words or Feynman diagrams to do this, is they've garnished my wages in some way. That may be the 8th Amendment extreme for the conditions, or negligent in the way they routed this Lagrangian to properly function out what all parties were considered. When I consider it a grievance about this yard sales painting that they sold that I marked up later on and was on the news for, and then a contract comes around later because some other people have broken this system and law being broken the way it is. You want to do what you can to fix it. So again, I'm just going to freeball it, because again, I could put in the answers. I feel you could also click and put these in. Again, don't undersell this. If you're supposed to learn this, or you're feeling... What? That's constitutional law for you. And, what? Alright, so it's telling me what book I'm supposed to find this in. If I registered that question, this how it came in. You're telling me you have to literally understand, what library would you have to go to in order to find that information, seeing that I don't believe it's anywhere in here talking about those things. Is that Alpha's fault? Or is constitutional wrong here about what's going on? This is an important test. Just because some bar put this out here doesn't make it exactly right, man.